I'm Nick Eckert, and I'm going to give you a quick introduction to the GDPR to bring you up to speed about some of the primary tenets of the regulation so that you're better prepared to answer at least broad questions that might be posed to you. So the first question is, what is the GDPR? It replaces the Data Protection Directive from 1995. It's probably the biggest change in European data protection law in the 20 plus years since then. The major technical difference between a directive and a regulation is a legal act that becomes immediately enforceable in all the EU member states, whereas the previous directive was essentially a directive that needed to be transposed into member state national law. So with this data protection regulation, there's now a new law that's going to replace all of the existing data protection laws, which all had slight variances in them, so it's making it much more unified. On top of that, the United Kingdom has stated that they will be enacting a new data protection law that will largely put into practice the GDPR as it exists. So even with Brexit coming down the pike, the GDPR will become the law of the land in the UK. So what was the Commission trying to do with the General Data Protection Regulation? It was trying to do three things. It was trying to create a regulation that protected individuals' personal data, individuals being EU citizens and EU residents, but it wanted to do that without restricting the free flow of data. So protecting individuals' rights in relation to their personal data without impacting businesses. It sought to harmonize data privacy and data protection rules across the European Union. As I indicated before, with a directive, each member state had implemented its own variations. And it also sought to empower member state supervisory authorities by actually giving them powers to sanction non-compliance with the regulation. All of you have probably heard about that. That's why the GDPR is so much in the news, because of the new sanctions and fine that member state supervisory authorities can now levy. The clock is ticking on the GDPR. On the 28th of May 2018, it will become law throughout the European Union. So companies have until then to comply, or at least they have until then to be in a situation where they're at risk of non-compliance. So a big question is, who has to comply? So any business or organization with an establishment in the European Union needs to comply. There are now national data protection authorities that have been appointed in every member state. These data protection authorities, it's the ICO in the UK, for instance, Information Commissioner's Office, have the ability to interpret and implement the regulation as well as levy fines. So they are responsible for the implementation and in their member state jurisdictions for all of the organizations. But it extends beyond that. It's not only organizations and businesses with an establishment in the EU, it also covers any businesses outside of the European Union that offer goods or services to residents or citizens of a European Union member state, or do any systematic monitoring of individuals in the European Union. So what that means is any organizations or businesses outside the European Union have to comply. And in order to comply, they actually need to appoint a representative in the European Union. So what are the core rules? As I mentioned before, the data protection regulation is replacing a data protection directive. As such, most of the core rules are the same. The scope changes slightly. It focuses on personal data, just like the previous directive, but the scope of what is personal data has changed slightly. Personal data is any information that can be identifiable to an individual. The definition of personal data is slightly broader, so an IP address tied to an individual that can indicate that individual's location, so an online identifier of some sort, is now also considered personal data. Photos on social media are considered personal data. So the rules focus on any personal data that is processed by either a controller or a processor. A controller is a company that holds the personal data and decides how that personal data is being used. A processor is a company that in some way processes or holds that personal data, but is doing it on the instructions of a controller. Under this regulation, one of the main changes is that the processor and the controller now share liability. As a result, it's very important that the controller gives clear instructions, usually via a written agreement, to the processor specifying what processing that they can do. The regulation also defines sensitive personal data types. These sensitive personal data types are ones that are personal data that can potentially be used to influence an individual's behavior. This has been expanded to include genetic and biometric data. In the past, in the previous directive, it also includes data such as philosophical or political orientations, religious orientations, ethnic or sexual orientations of individuals. So what's outside the scope of this? So anything that's outside of EU law is obviously outside the scope. Any border checks or immigration are outside the scope of personal data. Any household activity is outside of it, and law enforcement and public security is outside of it. The regulation focuses on 6 primary principles. Those principles are lawfulness, fairness, and transparency. So it basically says that the use of an individual is known as a data subject under the regulation. So the use of a data subject's personal data is okay if it's used to deliver a good or a service that's lawful and fair, and if you have the data subject's consent, so that's transparent and lawful. So there's a number of legal bases for processing a data subject's personal data. And if you're processing a data subject's personal data, you need to make sure that you comply with those. There are additional concepts are purpose limitation. That means that the personal data that you collect, you have to define what the purpose is that you're using that personal data for. Data minimization is another principle. This is the concept that you should not collect any data other than data that you need for the purpose that you've defined. Accuracy is the concept that you have an obligation to make sure that the personal data that you have is correct and accurate. Retention, this is a concept that you should not hold the personal data of individuals for any period longer than what is required for the purpose that you are processing that personal data. Integrity and confidentiality, I think those terms speak for themselves. And there's a final concept that isn't included in these 6 principles, but that is a big part of the GDPR that I want to mention here, which is accountability. So the organizations are accountable for showing their compliance with the GDPR. So coming back to the data subject's rights, as I said at the beginning, this is the primary reason for implementing this new regulation. As I said, data subjects are any individuals on which you have personal data, and personal data is any information relating to an identifiable natural person. So that might be names and contact details, it might be an identification number, their location, it might be health information. But the GDPR goes beyond personally identifiable information, as I stated before, to include online identifiers. Things like IP addresses, cookie identifiers, or even radio frequency ID tags. So anything that might show your location is considered to be a personal data point on a data subject. So as a controller, you are now required to uphold the following individual rights and to make sure that you've communicated these rights to individuals. The right to be informed of, so that's the right of the who, why, what, and where of the personal data that you're processing. The right of access to individuals' personal data. The right to rectification of data which is out of date, inaccurate, or incomplete. The right of erasure, this is the famous right to be forgotten. So the right of erasure of personal data which is no longer relevant to a purpose. The right to object to processing, like direct marketing, so opt-outing of consent. The right to restrict processing of personal data. So if a data subject has a disagreement about how you're using their data, you have to restrict yourself from processing that personal data. And the right to data portability. So they can request that you provide to them in a digital format the data, personal data that you hold on them. Finally, there's some other rights in relation to automated decision-making and profiling. So if your organization does automated decision-making and profiling on individuals, those data subjects have the right to request that that there's a manual intervention into the processing of their personal data. I want to speak a little bit about consent. Consent is a very important concept in the GDPR. Consent needs to be demonstratable by the controller. It needs to be clearly distinguishable from other matters. It needs to be intelligible, it needs to be easily accessible, and it needs to be in clear and plain language. There needs to be an easy means for the right to withdraw consent, as we just discussed previously. Data subject rights, one of those rights is their right to withdraw, so it must be as easy to remove your consent as it was to give it. And consent obviously needs to be voluntary. If a service is conditional on consent, then that is not freely given consent. Consent cannot apply to an open-ended set of processing activities. It must be limited to a specific context. It cannot be bundled as part of a wider set of terms and conditions. And it cannot be assumed by silence or inactivity. Under the GDPR, consent is required for some specific areas. So to collect personal data of a child, consent of a legal guardian or adult is required. To collect sensitive personal data such as racial or ethnic origins or trade union memberships or biometric data, consent is required. For automated decision-making and profiling, consent is required. For international transfers of data outside of the European Union, in some cases, consent is required. For direct marketing to prospective customers, consent is required. For personal data that is not collected directly from a data subject, but you obtain it from a third party, that third party needs to have the consent of the data subject that they're providing it to you. For cookie usage, consent is required. For purposes which differ from the original purpose of personal data collection. For instance, if you collect data, personal data on a data subject, and you want to share that with a loyalty program, consent would be required. So again, in summary and in practice, for consent, you need clear affirmative action. You need a written, electronic, or oral statement. It should be explicit, like ticking a box on a website or choosing a technical setting, or some other statement or conduct that the individual needs to take. Silence, pre-ticked boxes, and inactivity are not consent. And you need consent for all the purposes that you're using. If you have consent for certain purposes, that does not mean you can then go use the personal data for another purpose. I want to speak just briefly on children's personal data. Under the GDPR, a child is anyone under the age of 16 years old. If someone is lower than 16 years old, then consent is only valid if it's authorized by a parent or legal guardian. In some member states, they have lower ages. There's the ability to derogate a lower age by a member state. In the United Kingdom, that age is 13. The minimum age for a child is 13. In all cases, you need to be able to demonstrate reasonable efforts to verify the age of an individual or child if you're working with children. For e-commerce, you must get parental consent if you're collecting personal data of a child. In no cases can children be subject to automated decision-making or profiling. And of course, you must communicate with children in clear and simple language. How do you do that? That dovetails into the privacy notices, where the GDPR is relatively prescriptive in terms of what it requires. Privacy notices need to clearly state the following information. What contact details for a DPO, if any? What contact details for your organization? What is the legal basis for processing that you're using for the personal data you're collecting? If one of those legal bases is legitimate interest, you need to state what that legitimate interest is. If you're making any data transfers of the individual's personal data, you need to state what those data transfers are and what the legal basis of those data transfers are. You need to explain to data subjects how they can obtain further details of safeguards that are in place. You need to state what the retention period is on the personal data that you're collecting, or at the very least the way it is set. You need to state what their extended individual rights are, those data subject rights I showed you earlier. You need to state clearly what their right of complaint is, and how they speak to the DPO or the Data Protection Authority. And if you're collecting data from a third source, meaning it's indirectly obtained, you need to state what the source of that data is. So obviously, in many cases, you're going to need legal oversight or a tool like GDPR 365 to help in the creation of privacy notices that actually cover all of those areas. The other important area relating to privacy notices that's prescriptive is that if you are collecting the information, you have to notify the individual at the time of collection. If you did not obtain the information directly, then that's impossible, obviously. But you need to then get that privacy notice communicated to those individuals in a reasonable period of time. So as I said, accountability is a huge part of the GDPR. That's why tools like GDPR 365 are available, so that you're actually able to demonstrate accountability. That means you need to be able to make sure that you can demonstrate your compliance with the 6 general principles. So some of your new responsibilities under the GDPR that you're going to need to be able to demonstrate are your implementation of data protection policies. So that's compliance checklists and proof that you've gone through them. Proof that you're using data protection by design and by default in your processes. Compliance checklists, again, that you've gone through, and data protection impact assessments. All the record-keeping obligations that you need. Cooperation with the supervisory authorities, so a point of contact between your organization and the supervisory authorities. Prior consultation with data protection authorities if you have potentially identified high-risk cases within your organization. And in some cases, you may need a mandatory data protection officer. So what is a data protection officer? Well, not all businesses need to appoint a data protection officer, but some businesses do. If you are a public authority, you need to appoint a data protection officer. If you undertake regular and systematic monitoring of data subjects, you need to appoint a DPO. If you process sensitive or criminal personal data, you need to appoint a DPO. But what is a DPO? So a data protection officer is somebody that has expert knowledge of data protection law, somebody that has the ability and authority to fulfill tasks related to data protection in your organization. They can be a staff member, they can be an external consultant. They need to be in a position where they can inform and advise the controller and the processors of their organizations. They need to be in a position where they can monitor compliance of the GDPR and also monitor member state data protection laws and any derogations or changes to those. So they have to be able to assign responsibilities within an organization. They have to be able to raise awareness and provide training. They need to be able to audit practices within an organization. They need to be involved and give advice in data protection impact assessments, and they need to be a point of contact and cooperate with data protection authorities when that is required. Controllers and processors that have to appoint DPOs also have certain responsibilities towards those DPOs. They need to provide them resources. They need to give them access to personal data and processing operations. They need to make sure that those individuals can maintain their knowledge and expertise. The regulation also provides some protections to DPOs. So DPOs cannot be instructed on how to do their job. They cannot be dismissed or penalized for performing tasks related to their data protection requirements under the regulation. They must be able to report to the highest levels of management. They must be able to be contacted directly by data subjects, and they are bound by secrecy and confidentiality. So obviously we can't talk about the data protection regulation without talking about data security. One of the things the data protection regulation does is actually define quite clearly what are high-risk areas related to personal data and what are risk areas related to personal data. High-risk areas are large-scale data processing, regular and systematic monitoring of data subjects, and the transferring of data to third parties. All of those are areas where personal data can potentially be misused or where it is at risk. Other risk areas are unauthorized or unlawful processing of personal data, accidental loss, destruction, or damage of personal data, and then also how processing is done on sensitive personal data or children's data. In all cases, appropriate technical and organizational measures need to be put in place to ensure for the security of data. This means encryption of data or pseudonymization of data. It means ensuring that ongoing confidentiality, integrity, availability of data, and resilience of backup and security solutions are in place and tested. In the case of backup, that the ability to restore lost data is there, and that processes are in place for testing those, not only the restoration, but also the resilience of the systems in place. The regulation understands that it can't dictate what security systems are in place, but companies are to look at where the risks are there and then to implement the appropriate areas. The regulation also realizes that data breaches are not exceptions, they are things that occur. And as a result, organizations have a responsibility to notify their local supervisory authority in not less than 72 hours after they have become aware of a personal data breach. In case of the event that it's not likely to result in a risk, they don't need to notify it, but you need to keep a log. In all cases, we would recommend that if there is a personal data breach and you become aware of it, make notification to the supervisory authority. And in some cases, if the personal data breach is of sensitive information, then there's also a legal obligation to inform the data subject of the data that has been breached. How data processors are dealt with under the regulation has changed completely under the Data Protection Directive. Processors had limited liability. All of the liability sat with the data controllers. Now, the processors have joint and several liability with the controllers. So as I said before, processing under the GDPR is only lawful under certain circumstances. Those are if the data subject is given consent, if processing is necessary for the performance of a contract or to take steps prior to entering into a contract, if processing is necessary for compliance with a legal obligation to which the controller is subject, if the processing is necessary in order to protect the vital interests of a person, or if the processing is necessary for the public interests or for an official authority. Finally, it does give a little bit of room saying processing is lawful if it's in the legitimate interests of a controller or a third party. The controller or third party is able to define those legitimate interests, but those legitimate interests need to be communicated to the data subject. There is a requirement under the GDPR for controllers to use safe processors. This means that there needs to be a written authorization and contract between the controller and the processor defining what personal data the processor is able to process. There needs to be documented instructions on that processing. Persons who have access to that personal data at the processor need to be under confidentiality obligations. The processor needs to have defined security measures in place that the controller can audit. If the processor is then going to provide the personal data to another processor for further sub-processing, that authorization needs to be included in writing in the contract between the controller and the processor. If the controller needs to request help from the processor, that the processor has to be obliged to assist the controller. And also the processor needs to be able to demonstrate that it has sufficient systems in place for restoring data in the case of deletion. It also needs to ensure that if the agreement with the controller is severed, that they can demonstrate either a return of all data or deletion of all data on their systems. The GDPR also addresses transfers outside of the European Union. This applies to controllers or processors that are not established in the European Union if their processing activities relate to either the offering of goods or services, and that's irrespective of whether or not a payment is required, or the monitoring of individuals' behavior if the individual is a resident in the EU, if they're an EU data subject. If this is the case, then all non-EU-based controllers or processors must appoint an EU-based representative, who that representative will then share the legal liability so that the GDPR can be enforceable on that non-EU processor or controller of EU data subjects. So those are all the broad changes in relation to the data protection regulation that have come through. In addition to that, there's the sanctions, which I want to address just because everybody talks about it a lot. I think you've all heard about the headline issues. Essentially what the data protection regulation has done is it's allowed for the creation of or the assignment of a data protection authority in each member state. That supervisory authority appoints one or more authorities, it's been one so far, who are responsible for monitoring and enforcing the impacts of any processing of data subjects within their territory. And they're the ones who are also then responsible for levying any sanctions or issuing any warnings. The severe breach top line, I think you've all heard, is 20 million euros or 4% of worldwide turnover of the undertaking, whichever is higher. And it's triggered by infringement of the data subject's rights or infringement of basic data protection principles or unlawful international transfers or non-compliance with any orders that the supervisor authority may have issued that then haven't been followed up on. Lesser sanctions come into line for things like failing to issue the supervisory authorities information related to data breaches and some lesser transgressions. So I hope this gives you some oversight as to some of the main concepts of the GDPR. This is only a scratch on the surface. I'm sure you've probably got many more questions. Please don't hesitate to contact us if you do. Thanks for your time.